The moment my brother pointed at me across the conference table and said, "She doesn't belong here. She never has," I didn't flinch. I didn't look away. I just set down my coffee, folded my hands, and waited. Because I had been waiting for exactly this moment for 3 years. Let me take you back to the beginning. I grew up in Sudbury, Ontario, in a house that always felt like it had 2 temperatures. Warm when my brother was in the room, cold when it was just me. My brother is 7 years older than me, and from the time I was old enough to understand what approval meant, I understood that I was not the one who received it. He was the one who got the standing ovation at the dinner table. He was the one my father drove 4 hours to watch play hockey. He was the one who inherited my grandfather's desk when Grandpa passed. I got a card that said, "We love you, sweetheart." No signature from my brother. My name is not important right now. What's important is what I built and what I had to survive to build it. My grandfather, Grandpa Art, everyone called him, started a small property management company in the late 1980s. Nothing glamorous. He managed apartment buildings across northern Ontario, handled maintenance requests, dealt with city inspectors, showed units to new tenants. It was unglamorous, exhausting work, and he did it with 2 employees and a landline phone for most of his life. By the time he retired, Ardmore Property Solutions had grown into something respectable, 42 units across 3 municipalities. A name people in Sudbury actually recognized. My brother, whose name is Wesley, had decided by his mid-30s that Ardmore was his birthright. He joined the company when Grandpa's knees started giving out. He learned the minimum. He hired a property manager named Gary who actually did the work. He put his name on the door and started introducing himself at Chamber of Commerce events as the next generation of Ardmore. I was 26 when I asked Grandpa if I could help too. I had just finished my Bachelor of Commerce at Laurentian. I had a concentration in real estate and finance. I had spent 2 summers interning at a property management firm in Barrie because I actually wanted to learn the industry from the ground up, not just inherit a title. I came home and I sat across from Grandpa at his kitchen table, the same table where he used to let me do my homework while he did his accounts, and I asked him if there was a place for me at Ardmore. He looked at me for a long moment. Then he said, "There's always a place for you here, sweetheart, but your brother runs things now. You'd have to talk to him." I talked to Wesley. He laughed. Not a mean laugh exactly. More the kind of laugh that tells you the person doesn't take you seriously enough to bother being mean. He said, "What do you even know about property management?" I told him about Barrie. He said, "That's a completely different market." I told him I had a commerce degree. He said, "Book knowledge." I told him I wanted to start in accounts, learn the systems, work my way up. He said, "I'll think about it." He never thought about it. Or if he did, the answer was no, delivered through silence. I went back to Grandpa. Grandpa listened. He asked me what I really wanted. I told him I wanted to build something. I told him I didn't need to be handed Ardmore, I wanted to earn something of my own. He nodded slowly and said, "Then earn it. And don't wait for permission." 2 weeks later, he called me. He told me he had set aside a portion of his personal savings, $240,000 in a separate account. He said it was mine, not from the company, not from the family estate, just from him. He said, "I watched you your whole life. You work harder than anyone I know. I want to see what you do with a head start." I was 26 years old and I was holding the phone so tightly my hand ached. I want to be clear, I did not tell anyone about that money. Not my parents, not Wesley. I opened a numbered company, 2847391 Ontario Inc., which I later renamed Glencroft Capital, and I used Grandpa's gift to make my first acquisition. A 6-unit residential building on Scorch Street in Sudbury that the owner wanted to unload quickly because he was relocating to British Columbia. I paid under market because I could close in 21 days and he needed cash. I spent 3 months doing cosmetic renovations with 2 subcontractors I trusted. I raised the rents to market rate. I refinanced the property 12 months later and pulled out enough equity to put a down payment on a second building. This is how it works when you're building something real. You don't start with a press release. You start in the dark, doing the math at midnight, triple-checking your cap rates, losing sleep over vacancy risk. Nobody sees the work. That's fine. You're not doing it for an audience. By the time I was 29, Glencroft Capital managed 11 residential units and had a small but growing reputation among property sellers in Northern Ontario as a buyer who closed cleanly and didn't waste anyone's time. I had 2 part-time employees. I had a relationship with a commercial lender at BDC, the Business Development Bank of Canada, who took me seriously. Wesley, meanwhile, had run Ardmore into trouble. I didn't know the details at first. I heard things through the family. My mother mentioned that Wesley had some cash flow issues. My aunt said she'd heard he let some properties fall behind on maintenance and lost a couple of long-term tenants. I didn't pry. It wasn't my business. Then Grandpa called me again. This time his voice was different. He came to me for money, Grandpa said. $300,000. He says Ardmore needs it to stay current on the mortgage payments. I asked if Grandpa was going to give it to him. There was a long pause. I already gave him money twice before, Grandpa said. He told me it went to renovations. Gary. You know Gary, the property manager. Gary left last year. Wesley said Gary quit. I heard from someone else that Wesley let him go to cut costs. Another pause. I don't think he knows what he's doing, sweetheart. I sat with that for a moment. Don't give him the money directly, I said. If you want the company to survive, the money needs to go somewhere it can be tracked. Grandpa was quiet for a while. Then he said, "What are you suggesting?" I told him about Glencroft. I told him about the 11 units, the BDC relationship, the clean books. I told him that if Grandpa wanted to protect Ardmore, the smartest structure was to have Glencroft extend a secured loan to Ardmore, properly documented, registered with the province, secured against the real estate assets. Not a gift. A loan, with interest, with a repayment schedule, with Glencroft holding a general security agreement over the company's assets. If Ardmore recovered, great. Grandpa's money was protected and the company survived. If it didn't, Glencroft would be the first in line when the assets were liquidated. The money wouldn't just disappear into whatever Wesley was doing. Grandpa said, "Does Wesley need to know it's you?" "Not unless you want him to," I said. We used a lawyer. A real estate solicitor in Sudbury named Mr. Kasperzak, who knew Grandpa from years of doing Ardmore's title work, to structure the transaction. The loan was $320,000 from Glencroft Capital to Ardmore Property Solutions. Registered as a first priority security interest under the Ontario Personal Property Security Act, with the real estate holdings serving as collateral under a separate mortgage instrument. Everything was above board, everything was filed. Mr. Kastrak made sure of it. Wesley received the funds. He signed the loan documents. He signed them without reading them carefully, something I would learn later. And he told Grandpa he had secured bridge financing from a private investment group. He did not ask questions about who was behind Glencroft Capital. In my experience, people who are desperate for money often don't. For about 8 months, nothing happened. Wesley made 2 payments on the loan and then stopped. I sent formal notices through Mr. Kasperzak's office. No response. I waited another 60 days as the agreement required. Still nothing. Then Grandpa's health declined sharply. He had a cardiac event in November, spent 2 weeks in Health Sciences North, and came home with new limitations and a new awareness of how little time he might have. He updated his will. He called me. He told me what he had done. He had left 49% of Ardmore Property Solutions to me. Wesley received 51%, which still made him the controlling shareholder. But Grandpa had quietly transferred his personal ownership stake. The 49% he had retained when he handed operations to Wesley. Into my name, registered through a separate holding. He said, "I don't want you to be shut out, sweetheart. You've earned a seat at the table." He passed away in February on a Tuesday morning. While I was on a call with a contractor in Timmins, I didn't cry until I was alone in my car in the parking lot behind my office. I sat there for 40 minutes. I thought about the kitchen table and the homework and the phone call where he told me to earn something and not wait for permission. I thought about how he was the only person in my family who had ever looked at me and seen exactly what I was capable of. Then I drove home, and I kept working, because that was what he would have told me to do. Wesley found out about the 49% 3 weeks after the funeral, when Grandpa's estate lawyer, a woman named Ms. Okafor in Sudbury, held the formal reading. He didn't take it well. He called me that same night. He was not calm. "You manipulated him," he said. "He was an old man and you convinced him to cut me out." I said I hadn't cut him out of anything. He still had 51% in operational control. "That's not the point," he said. "The point is you went behind my back. The point is you've been scheming your whole life to take what I built." I almost laughed at that, what he built. Ardmore had 2 outstanding code violations, a missed mortgage payment, and a loan in default that I personally held. But I didn't say any of that. I said, "I think we should let the lawyers sort out next steps." He said, "You don't belong in this company, you never did." He hung up. The lawyers could not sort it out. Wesley hired a family law litigator, a man named Mr. Tessier, who sent a letter arguing that my grandfather's transfer of the 49% stake to me was the product of undue influence, that Grandpa had been medically vulnerable at the time of the transfer, and that the transaction should be set aside by the court. He was also, separately, in default on the Glencroft loan by $180,000. It took 11 months to get to the hearing. I am not going to pretend those 11 months were easy. There were moments, more than I want to admit, when I sat in my apartment in Sudbury, eating takeout from the Vietnamese place on Elm Street, wondering if I had miscalculated everything, wondering if Wesley was right that I didn't belong there, wondering if Grandpa's faith in me had been misplaced. Those moments passed. I went back to work. The hearing was scheduled for a Thursday in October at the Ontario Superior Court of Justice before a judge I had not encountered before, my own lawyer. Ms. Beaumont, who had represented Glencroft in its commercial dealings for 2 years and who I trusted completely, had advised me to say as little as possible in the courtroom. "Let me handle the procedural arguments," she said. "Your job is to sit still and look like the adult in the room." I could do that. Wesley arrived with Mr. Tessier and with my parents, who had agreed to provide affidavit evidence supporting Wesley's claim about Grandpa's mental state. My mother would not meet my eyes when they walked in. My father looked at me the way he always looked at me, like I was a problem he hadn't figured out how to solve yet. The room was not large. It was a standard motions court, beige walls, fluorescent lighting, the kind of government building aesthetic that is specifically designed to make you feel like whatever you're experiencing here is very ordinary, and probably your fault. The judge, a woman I'll call Justice Arsenault, had silver hair pulled back, reading glasses on a chain around her neck, and the precise manner of someone who has heard every possible variation of family dispute and is no longer surprised by any of them. Wesley's lawyer spoke first. He argued that the transfer of shares was invalid due to undue influence. He cited Grandpa's cardiac event, his hospitalization, his age. He submitted the affidavits from my parents. Then he made a mistake. He said that the loan, the Glencroft loan, was also suspect. He argued that the loan had been structured by someone acting as a de facto advisor to my grandfather without proper disclosure, and that the security interest should be examined for validity. He was trying to knock out both the shares and the loan at once. Ms. Beaumont let him finish. Then she stood up. She submitted Grandpa's medical records from the period of the share transfer, obtained with the consent of the estate. The records showed that at the time of the transfer, Grandpa had been assessed by his cardiologist and found to be cognitively intact. She submitted a letter from the cardiologist confirming same. She submitted the notes from Ms. Okafor, the estate lawyer, who had met with Grandpa alone, without me present, before drafting the transfer documents, and who had recorded her professional assessment that he was of sound mind and acting voluntarily. She submitted the Glencroft loan documents, registered under the PPSA, signed by Wesley himself. Then she submitted Glencroft Capital's corporate registry documents, including the name of the sole shareholder and director of Glencroft Capital. Mine. I watched Wesley's lawyer turn to look at my brother. I watched my brother's face go through several things in quick succession. Confusion, then the beginning of understanding, then something I can only describe as the color leaving a person's face. Justice Arsenault leaned forward slightly. She looked at Wesley over her reading glasses. "Mr. Ardmore," she said, "are you aware that the loan your company receives from Glencroft Capital was extended by your sister?" Wesley did not answer immediately. His lawyer put a hand on his arm. Wesley said, No, I didn't know that. You signed a loan agreement for $320,000. Justice Arsenault said, in the tone of someone reviewing a document they find straightforward, secured by a first priority general security interest against all assets of Ardmore Property Solutions, in favor of Glencroft Capital, without conducting any due diligence on the lender. Mr. Tessier said, "Your Honor, we would argue that the failure to disclose the identity of the lender represents a material." Justice Arsenault raised one hand, not rudely, just with the authority of someone who has heard enough. "The identity of the lender was available through the public corporate registry," she said. "Glencroft Capital is a registered Ontario corporation. Its directors and officers are public record. The argument that non-disclosure of a matter of public record constitutes fraud or misrepresentation is not one I'm inclined to accept." She made a note. "Continue." Mrs. Beaumont continued. She submitted Glencroft's 3 formal demand letters, all sent by registered mail to Ardmore's registered office, all unreturned and unacknowledged. She submitted the record of payments, 2 made, then nothing for 14 months. She submitted the current outstanding balance, $194,000, including accrued interest at the agreed rate. Then she made the argument I had been waiting 14 months to hear articulated in a courtroom. Glencroft Capital was the first priority secured creditor of Ardmore Property Solutions. In the event of default, which had occurred and been documented, Glencroft was entitled to enforce its security interest. That meant Glencroft had a legally registered claim against all of Ardmore's assets. The real estate, the equipment, the receivables, the operating accounts, everything. Enforcement proceedings could begin immediately upon the court's acknowledgement of the default. Additionally, I held 49% of Ardmore's shares through the estate transfer, which Ms. Beaumont argued was fully valid on the evidence submitted. Taken together, I was both the company's largest creditor and its second largest shareholder. Wesley was the majority shareholder of a company that owed his minority shareholder sister close to $200,000 and whose assets she could move to seize. Wesley stood up. His lawyer tried to stop him. He stood up anyway. She planned this, he said. His voice was louder than the room called for. She planned this from the beginning. She set a trap. Justice Arsenault looked at him. Mr. Ardmore, she said, you are represented by counsel. Please communicate through your lawyer. She's been doing this for years, he said. She's been trying to take the company since Grandpa got sick. She manipulated him. She set up this shell company, Mr. Ardmore. And she convinced him to give her money and she used it against us. That's not business, that's a scheme, Mr. Ardmore. Justice Arsenault's voice did not rise. It just became very still. If you do not sit down, I will ask you to leave this courtroom. You may continue your submissions through counsel. My brother sat down. His face was red. His hands were on the table and I could see from where I was sitting that they were not entirely steady. My father, who was in the gallery behind the bar, said something quiet to my mother. I didn't hear what. My mother finally looked at me, directly at me, and I couldn't read her expression. I don't know what she was thinking. I'm not sure I wanted to know. Ms. Beaumont wrapped up. She asked the court to dismiss Mr. Tessier's application to set aside the share transfer, and to acknowledge the validity and enforceability of Glencroft's security interest in Ardmore's assets. Justice Arsenault took a 15-minute recess. When she came back, she was direct. She dismissed the undue influence claim. She found the medical evidence insufficient to establish any impairment at the time of transfer, and found that Ms. Okafor's independent verifications satisfied the requirements of the Succession Law Reform Act. The share transfer stood. On the Glencroft loan, she acknowledged the default and confirmed the validity of the security interest. She noted that enforcement proceedings were a matter for Glencroft to initiate through the appropriate process, but she was not going to use the court to invalidate a properly registered, properly documented commercial loan because the borrower was unhappy with the identity of the lender, she said, looking briefly over her glasses at both sides of the room. Family disputes that find their way into commercial litigation tend to be complicated by emotion. The law is less complicated. The documents here are clear. Court was adjourned. In the hallway outside, my parents were talking to Mr. Tessier in low voices. Wesley walked past me without speaking. He didn't look at me. I don't know exactly what he was feeling. And I have spent some minutes trying to decide if I care. I think I care a little. I think somewhere underneath the 3 years of legal filings and demand letters and sleepless nights running cash flow projections, there is still a version of me who wanted my brother to see me. Not defeat me. Just see me. But that's not what happened, and I've made peace with the difference. Ms. Beaumont and I sat in her car in the parking lot for about 20 minutes. She had a thermos of coffee. She poured me a cup. We didn't say very much. She told me I had handled myself well. I told her she had done the actual work. She said that was technically true, but that sitting still and looking like the adult in the room was a skill not everyone had, and I should not underestimate it. I started enforcement proceedings on the Glencroft loan the following week. Wesley negotiated. He didn't have much room to negotiate. A first priority GSA is not a suggestion, but there are always options short of full liquidation if both parties are willing to talk. We came to an arrangement. I'm not going to detail it here because it's still subject to a confidentiality term. What I will say is that Ardmore Property Solutions is now managed very differently than it was a year ago, and Gary, the property manager who Wesley had let go, is back. My 49% stake is still mine. It's in good hands, I think. My relationship with my parents is complicated. My mother called me about 6 weeks after the hearing. She said she hadn't fully understood what Wesley had done with the company finances. She said she hadn't known about the loan payments stopping. She said, "I didn't realize how much you had built on your own." She paused for a long time. "Grandpa knew, didn't he?" I said yes, Grandpa knew. She said she was proud of me. It was the first time she had said that without it being attached to something Wesley had just accomplished. I don't know what to do with that yet. I'm letting it sit. The Vietnamese place on Elm Street is still open. I still eat there, sometimes alone with my phone and my cap rate spreadsheets, sometimes with Ms. Beaumont when she's in the area. Last time I was there, the owner, a woman who's been running the place since before I started university, refilled my tea without being asked and told me I looked tired. I told her I was fine. She said, "You always say that." She's not wrong. But here's what I know. Sitting at that small table in Sudbury, 29 years old and tired and fine, Grandpa sat at his kitchen table and did his accounts and built something real for 40 years, and nobody gave him a standing ovation either. He just kept going. He kept showing up. And when it mattered, he looked at me and saw exactly what I was. That's the thing Wesley never understood and probably still doesn't. This was never about taking anything from him. It was about proving, to myself more than anyone else, that I could build something that couldn't be ignored. I think I've done that now. I think Grandpa would agree.